We're live.
Okay. Let's go on the record on cause number DC 194895, Sines versus Backer. Counsel, make your appearance.
Andrew Summerman and Alex Reisinger for the plaintiffs, Your Honor.
Greg Scott for the defendants.
All right. Let's go ahead and proceed.
Your Honor, this is plaintiff's motion to compel. We have two broad categories that I'd like to deal with. The first involves a police report and police information from the defendant, and the second is a whole myriad of objections by the defendant to various discovery matters. To set the stage for you, Your Honor, you may recall that we've been before this court before on several discovery motions, and we still have pending an order from the court with regard to striking the defendant's medical expert. As you may recall, the medical expert issue was that he relied upon a video that doesn't exist, and his methodology and his credentials didn't warrant his biomechanical opinions. Be that as it may, what we have before us now is dealing with a police issue. The counsel for defendant has late designated the police officer as an expert in this particular case. That late designation comes without documentation associated with it. Now, normally you would hear me even say, well, it's a public record, go get it yourself. It doesn't exist, Your Honor. We made our request for a police report from the police department, nothing. We did a Freedom of Information Act after we saw the declaration to find out what defense counsel is talking about, and nothing. Got nothing from them whatsoever. But counsel for defendant apparently is of the opinion that this police officer is going to render some opinions that may be negative to the plaintiffs. And so we're like, give us what you got on this guy then. Give us all the documents and, the opinions that he has. And we wanted to pose him. We wanted to pose the police officer. Counsel for defendant.
So there's a police officer. I've never seen this in 14 years. Or in really 20 years of practice where someone wants to depose a police officer, but there's not a police report? Is that
no? Well, none that is available through public means, Your Honor. At least maybe counsel for defendant has something that I don't have, but that's what I'm looking for. If you got it, give it to me, and I wanted to pose him too. And counsel for defendant says no, even though I've late designated this guy, we're beyond the discovery period. You don't get to depose him. And I'm like, you late designated him. Let me depose this guy and give me what you got on him. And counsel for defendant has refused those issues. And I have a second issue if you want to address the first.
Let's do the first. Mr. Scott?
Yes, Judge. They insisted on a March discovery deadline that I didn't want. They've blown that discovery deadline, now wanting to take the deposition of their doctor that they had 9 months to do. So while this lawsuit was pending for 9 months, they never told me that the Dallas police were called. They never identified a police officer in the disclosure responses, and they never told me that they tried to get my client thrown in jail that day. It was during the plaintiff's deposition that I learned for the first time that the police were called, that a police offense report, Judge, that's different than a police accident report, was filed. I learned for the first time. Now, they didn't disclose any police report. They didn't mention it. So I'm totally clueless until I take the plaintiff's deposition. And I'll tell you, because I used to be a Dallas police officer, what happened in the parking lot that day is the police officer very likely gave him his business card, gave him a 5-inch by 4-inch postcard that had the police offense report written on it so he could go get a copy of it later. And while they're claiming they don't know anything about it, they just want what we got. I promise you that afternoon, the plaintiff had the police officer's business card and the police offense number. So why didn't they want to designate him, Judge? Well, you can guess why. Because when the police officer showed up on a hit and run, what's the most important question in terms of criminal offense? If the person was injured or not. And of course, the plaintiff told the police officer multiple times that afternoon that he was not injured. And then a detective was assigned, and that detective called the plaintiff days later, and the plaintiff told him the same thing, I'm not injured. But of course, after that, he hires a lawyer, and now we're here where we're at.
Let me ask a question. Do you have a copy of this offense report?
I do. I contacted the liability insurer and I said, look, I have no way to research this. See what you can do and have your adjusters or private investigators try and find something that was filed that day by this person. And I do have a copy of it. And what I have is the original offense report that was filed by that police officer that day. I late designated him because I didn't have that police report and didn't know his identity because they withheld it. And now I found them, I caught them, and I designated them as soon as I knew about him. Then they're trying to play innocent. Oh, I don't know anything about it. It's baloney. And it's just an example why this is like the 5th hearing on this fender bender, Judge. Maybe the 6th hearing. But the ironic thing, Judge, is no fenders were even bent in this thing. There was no damage to either vehicle. So as you can tell, my patience is very thin with these people.
Your Honor, may I reply?
Sure.
You may have read counsel for defendant's response. His response was basically that Alex Reisinger is a bad person. And that's been his response every time. We would like to depose the police officer. We would like documents. Alex Reisinger is a bad person. Not true. Glad to defend her. Not relevant to the issues at hand. The issue at hand is he is late designated a police officer. I want to depose him. He says he has documents now. He won't give them to me. I can't get them. I don't know what he's talking about. He's right. I don't know what he's talking about. Produce them is what I'm asking this court to order him to do. Produce the documentation. Let us read what this terrible, awful report says that he says that it exists. And let's go to close the police officer that's been late designated. It's not an unreasonable request, Your Honor.
It is if you have a discovery deadline that you've blown and that you didn't take the depositions before you had the chance. That's the problem here, Judge. They want the rules to apply to me, the deadlines, but the deadlines don't apply to them. They want to take their doctor months after the discovery deadline passed because we didn't pay them the extortion money. And I couldn't have designated the police officer because they didn't identify him. And if my insurance company can get a copy of the offense report, so can they.
Your Honor, may I be heard?
Sure.
Your Honor, we didn't designate him. He did. Now, I'm not asking to depose somebody I late designated. I don't think this cop has anything to do with it. If Your Honor just wants to strike him because he's been late designated, okay by me. But if we're late designating and he says that this guy exists and he has information, produce it.
Yeah. I mean, I guess the way I've always done this before, I'm not exactly sure. I can kind of trying to think if I've ever had a case where someone had an offense report and not I'm sure there has been, I just can't remember that, and not a police report. But normally if there's a late designation, then I would allow a deposition to take place. Did you guys request, I assume you did, any top reports from the experts, right? Or anything?
Yes, Your Honor, we did, of course, yes.
So yeah, go ahead, and you're going to need to, I mean, Mr. Scott, do you want to call this guy at trial or not? Or kind of what are your thoughts about the police officer?
Yeah, it's pretty important because the plaintiff told him multiple times in the parking lot that he wasn't injured. It seems to me, though, the fair thing to do, if we're going to let him reopen discovery, is to have a new scheduling order with new deadlines. And you and I have had several trials, jury trials, where that very issue came up, where that was the reasonable thing to do. If they want to reopen discovery and have new depositions of their experts and this police officer, who's certainly not a retained expert, I have no control over him. All I know is what I see in the police offense report. So, Judge, if you are willing to allow them to take depositions after the discovery deadline, I respectfully request that you order us to sign a new scheduling order with new deadlines, because that would be the fair thing to do. So all the deadlines apply to both sides and not just plaintiff counsel.
Mr. Summerman?
Your Honor, I don't know what he needs. I'm glad to be accommodating. But if we're going to open up everything and allow him to start designating new experts, it just adds a lot of expense to a case that doesn't warrant it. And so as a result,
let me just give, I'm sensitive to what Mr. Scott is saying.
Sure.
And I'm very much, I'm sure, Mr. Scott has heard this many times in the past. I'm not sure if the rest of you have, is kind of what's good for the goose is good for the gander. You're wanting to take depositions late of his experts. He should be able to take, make it reciprocal. So if we're reopening expert depositions, we reopen expert depositions. So it's not fair to.
I got no problem with depositions, Your Honor. It's just designation that I'd have an issue with. I got no problem with reopening up expert depos times.
Expert deposition deadline is going to be extended to the day of trial.
Good, great. Your Honor, and that deals with our second issue, which is the deposition of our doctor, Dr. Mehta. We'd be glad to do that. Great, sounds terrific.
But I want to make it clear, if Mr. Scott has an expert that he needs to depose, I don't want you coming back and trying to say, look, we don't want him to be able to depose his expert. What's good for the goose is good for the gander. Mr. Scott wants to take his expert's depositions, even though it's past the deadline. He gets to do that. If you have expert depositions you need to take, you can do them. All expert deposition deadlines are extended to the date of trial, whenever that may be.
Thank you.
Does that address everything?
No, Your Honor.
So, Judge, so what I guess what I'm hearing is that not only can additional experts be deposed, but there can be an additional expert designation.
No, only people already deposed, already designated can be deposed. Anybody who's been designated can be deposed. Now, if you want to file a motion in the future to, hey, I need to, because I took this deposition, I didn't know this, and now I need to do a new designation, I'd be glad to hear that. But I want to be reciprocal. If you have an expert that's been designated and you haven't had a chance to depose that expert, you have the right to do that, or the other side's experts. All expert depositions are reopened. Designations are not reopened at this point.
And Judge, the reason why I bring it up is when we take the police officer's deposition, he is going to disclose the identity of the detective. And I don't know who that is, but that's a pretty important witness too.
I would imagine that I would if it comes out of the deposition and it has, I would probably allow that person to be designated and that deposition to occur. I would imagine. I mean, that just like if it turns out you had a doctor that you depose and you find out there's another doctor involved, I would probably allow that additional doctor to be deposed if it was necessary. So I would guess I would probably allow that if that person exists.
Judge, I guess I'll be totally candid and let this cat out of the bag. I eventually got their MRI films, and as you know, as I want to do, I hired my own independent radiologist and sent the films to him. And of course, the films show what you can, I guess they show, not what the plaintiffs claim. So I have a radiologist that I learned of, that I hired after the discovery deadline, that's going to say it was all degenerative. There weren't any tears, and this wasn't any acute injury. And I'm telling you this because I assumed you were going to allow us a new scheduling order, and that's who I want to designate, in addition to the detective.
We would be opposed, Your Honor, and that's not before the court.
I don't know that's reciprocal to what they're doing, but I'm glad to hear that in the future. I try to be fair to both sides. If they've done something like that without justification and you feel like, okay, they did this and then you do, I'd consider it. I'm not saying that I'll grant it or not grant it, but I don't think that's covered by what we're doing here today.
Understood, Judge.
Thank you, guys.
Your Honor, we do have another matter, Your Honor. We have a number of requests for production that we've asked for that have boilerplate objections to them. Your Honor, I don't think it's worthwhile to go through them one at a time. We've made a request of counsel for defendant for a privilege log because we want to see what's behind the objections, or at least know that there's something behind the objection. And if there is, we know what's the title of it. He has given us neither the documents, nor has he revealed in the privilege log if there are any documents behind it. Your Honor, what we're specifically requesting of this court at this time is that the if there is no document behind the objection, that the objection be withdrawn because there's no need for it. And if there is a document behind the objection and counsel for defendant feels that it's privileged, then please produce to us a privilege log so that we may consider whether we want it.
But what if the objection is about something else? What if they object for some other reason besides privilege?
Yeah, Your Honor, if there is a document behind it, we're asking you for an expansion of that, or if he's going to tell us today that there is a document that isn't privileged, but he's holding it for a different reason, I would ask that that be revealed at this time, that there is some sort of surprise document behind these objections. Let's have at it. That's the reason why we have filed the motion to compel. What we're looking for is, do you have it or not? If he gives me a privilege log, and I think it resolves the issue if it's more than just privilege. You know, if you're hiding a document, I want to know it. Just identify it.
Mr. Scott?
And that's disingenuous because they know that the cab company didn't investigate this 1.5 mile an hour incident. I haven't withheld anything, and I've told them that in several responses to all these motions that they have filed over the months. So there is nothing. There was no investigation. There are no witness statements. There are no investigative reports. There are things that I've done, but that's attorney work product, and that'll never be disclosed.
Your Honor, he hasn't, and I've asked him to remove his objections. If he's got nothing, remove your objections.
So, Mr. Scott, I'm going to give you, I guess there's three. Mr. Scott, let me just say this. If there are no documents, and this is such a small case, I would suggest you withdraw the objections. If there are privileged things besides things that you did directly, and you feel like you need to do a privilege log, that's fine. If there is some other document besides something covered by a privilege log or something that doesn't exist that you're protecting, then I think you need to have a conference with the other side, and I would send you into a breakout room. So, and you guys would need to confer on each individual request while I do this prove up. So what do you prefer?
Well, my objections are valid, otherwise I wouldn't have raised them. But I will, I'll look at them and we'll conference with plaintiff counsel this week and see if we can reach.
No. You're conferencing right now. So I'm sending you to the breakout room right now. So you either withdraw them or I send you to a breakout room to try to convert.
Yes, I'm not withdrawing them.
Okay. I'm going to put you guys into a breakout room. You guys try to work everything out. I'm going to send you with my intern, Dominique, and she will let me know when you, oh, no, that's not a good idea. Let me send you with, let's see, who all is here? Andrea, do you have Dominique's phone number?
No, but I have yours.
You have mine. Okay. Go ahead and text me when you're, when you guys are done. Okay. I'm going to put you into a breakout room.
Thank you.
All right, I need to put in Mr. Scott, Mr. Summerman, Miss Reisinger, and Miss Lee. Anyone else that I need to send over? Okay. Great. Okay. Before we get started with the prove up, have you already submitted a proposed judgment on this one?
Yes, I've never done this.
Yes, Your
Have,
Honor.
Your Honor.
Okay. And give me very basically, what's the breakdown in this case?
Do you mean settlement-wise, Your Honor?
I'm sorry, you cut out there. What did you say?
I'm sorry. Yes, I think I cut out. So the settlement breakdown is $8,200, and it's my understanding that $3,000 will be placed into the registry of the court, and then $5,200 will be issued to Julie Martinez and the Rafi law firm.
Okay.
That is correct.
And is there just one settlement or two settlements?
Just one settlement.
One settlement. Okay. All right.
There is just one, Your Honor. The other minor is no longer minor.
Okay. All right, let's go on the record on cause number DC 1918114, Jeremiah Perez versus Isaiah Young. Council, make your appearance.
Aisha Rafi, attorney for Jeremiah Perez, Julie Martinez individually, and as next friend of Henry Martinez.
Scott Whitcomb on behalf of defendant and Isaiah Thomas.
Okay, let's go ahead and proceed.
Maria
Sorry.
Marifera Seves here as the guardian ad litem for the minor HM.
Let's proceed.
Your Honor, Miss Martinez is on standby. She's in another room. She's recovering from COVID. So I understand we spoke with Mr. Perez. He will give the phone to Miss Martinez.
Is Julie Martinez the next friend of the minor?
Yes, Your Honor.
Okay. All right, so go ahead and do that.
You need one of them?
Interpreter is
Okay, can I
present
make a-
for the case that's just been called.
All right, let me go ahead and swear you in. Do you swear or affirm that you will faithfully translate the matters in this case from Spanish to English, from English to Spanish, to the best of your ability, so help you God?
Yes, I do. Giovanna Gonzalez, licensed court interpreter for the state of Texas, 2343.
Okay, Ms. Gonzalez, if you can go ahead and swear in Ms. Martinez, or
Sí.
translate for me. Do you
Yes, sir.
swear or affirm the
Señora
testimony
Martinez,
you give shall be the truth, the whole truth, and nothing but the truth?
yes, Your Honor. Let me find Miss Martinez. Señora Martinez?
Miss Martinez is coming on the screen.
Oh, I'm
Okay.
sorry.
Okay.
Sí, bueno.
Sorry, Judge. She
Sí,
has
señora
COVID,
Martinez.
and we're getting her on. She's trying to isolate in another room.
Okay.
Judy tiene que aparecer.
And what, and Mr. Heltowski is on the phone as well. What is he here for?
¿Le puede dar el teléfono a ella, por favor?
You're muted. I can't hear you.
A restraining order request, Your Honor.
Y usted no tiene que estar ahí. Henry no tiene que estar ahí, solamente Judy.
And it was actually noticed out, Your Honor, and Mr. Harder's not present at 4 o'clock for today.
Let me see.
Okay, Miss Martinez is here.
Okay. All right, ma'am, please raise your right hand.
Muy bien, señora Martínez. Se le pide por favor que levante la mano derecha para hacer juramento.
And I'm redoing the oath because when I did the oath earlier, apparently Ms. Martinez was not able to hear me, so I'm going to repeat that.
No.
Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Señora Martínez, usted jura solemnemente que el testimonio que va a prestar en este caso será la verdad, toda la verdad y nada más que la verdad.
Lo juro.
I do swear. Gracias, señora. Thank you, ma'am. Puede
You
bajar
may
la
pro-
manita. You can put your hand up.
You may proceed.
Vamos a proceder.
Who's going to ask the first question?
¿Por dónde vamos a comenzar con las preguntas?
Ms. Rafi, would you like me to take the lead?
Yeah, I can go ahead and take the lead. That's not a problem.
Okay.
Could you please state your name for the record, Miss Martinez?
Señora Martínez, por favor, ¿nos puede decir el nombre completo suyo, señora, para que conste en el acta?
Judith Martínez Benavides.
Julie Martínez Benavides.
And are you the biological mother of Henry Martinez?
Señora Martínez, ¿usted es la mamá biológica del joven Henry Martínez? ¿Es así?
Sí, así es.
Your
Yes,
Honor,
that's right.
I apologize. If we could use the minor's initials.
Oh, I'm sorry.
That's okay.
Yes, yes.
Disculpe, señora, debido a que estamos en video, se está pidiendo que cuando vamos a referirse al hijo suyo, no vamos a decir el nombre del joven, solamente vamos a utilizar sus iniciales, HM, únicamente cuando estemos hablando de él. ¿Está bien?
Ok.
Okay, Ms. Martinez understands.
And how old is HM today?
¿Qué edad tiene HM hoy día? ¿Cuántos años tiene él?
Desde el 2003, 16 años.
Well, let's see. He was born in 2003, so 16 years old.
Right.
17.
Or
And
17.
he was involved in a motor vehicle accident on November 22nd, 2018, correct?
El joven estaba involucrado en un accidente automovilístico, la cual sucedió el 22 de noviembre del 2018. ¿Es correcto, señora?
Correcto.
That's correct.
Specifically, he was involved in a motor vehicle accident. He was in a vehicle that was rear-ended by Isaiah Young, correct?
Más específicamente, señora, él estaba involucrado en un accidente automovilístico que más específicamente recibió un golpe por parte de atrás del vehículo del señor Isaiah Young. ¿Es correcto?
No, Jeremías.
El Isaiah Young era la persona que le pegó por detrás con el carro. ¿Es correcto?
Sí, correcto. Pero
Yes,
no sé cómo se llama el señor, pero sí es correcto.
Yes, I think that's correct. I really don't know the exact name of the gentleman, but yes, that is correct.
Okay. As a result of this crash, HM was injured, correct?
Resultante de este choque, HM quedó lesionado. ¿Es correcto?
Correcto.
That's correct.
Specifically, he suffered from injury to his neck, shoulder, and back, correct?
Más específicamente, él sufrió lastimaduras al cuello, los hombros y la espalda. ¿Es correcto?
Correcto.
That's correct.
And he treated with Atrium Chiropractic from November 29 through January 31st, correct?
Y él recibió tratamiento con el lugar que se llama quiropráctico Atrium Chiropractic y estuvo yendo desde el 29 de noviembre hasta el 31 de enero. ¿Es correcto, señora?
Correcto.
That's correct.
And since then, he has fully recovered from his injuries, correct?
Y desde entonces, desde que tuvo eso, él se ha recuperado por completo de sus lastimaduras. ¿Es correcto, señora?
Correcto.
That's correct.
And he does not have any more doctor's appointment related to that injury, correct?
Y él hoy día no tiene ninguna cita médica pendiente para que se vea con algún médico resultante de ese accidente. ¿Es correcto?
Correcto.
That's correct.
Now, as a result of this crash, you filed a lawsuit against Isaiah Young on behalf of HM, correct?
Resultante de este choque, usted presentó una demanda contra el señor que los chocó, que se llama Isaiah Young, y usted lo presentó a favor de el menor HM. ¿Es correcto?
Correcto.
That's correct.
However, a settlement has been reached in the amount of $8,200, correct?
Sin embargo, se llegó a un acuerdo por el monto de $8,200. ¿Está correcto?
Correcto.
That is correct.
And HM's net portion of that settlement is $3,000, correct?
Y el neto, o sea, la porción que le va a tocar a él, a HM, es el monto de $3,000. ¿Es correcto?
Correcto.
That's
Ya me
correct.
habían hablado.
¿Cómo?
Ya me habían hablado, ya me habían dicho.
Yes, that's correct. I was already told about that and I understood it. And yes, that is right.
Okay. Now, you understand that if you took this case to trial, a jury could have awarded you more money, less money, or no money at all, correct?
Señora Martínez, usted tiene bien entendido que si dado caso, el caso suyo, usted con el joven lo hubiera llevado ante un juez con un jurado a juicio, un jurado ha podido otorgarle o bien una mayor cantidad de dinero, una menor cantidad de dinero o nada de dinero resultante del juicio. ¿Entiende que es así, que es correcto?
Es correcto.
That's correct. Yes.
However, you feel that it is in HM's best interest to accept a settlement, correct?
Sin embargo, a usted le parece que es lo más favorable para HM el de aceptar este monto de dinero en vez de ir a juicio. ¿Es correcto?
Correcto.
That's correct.
And you understand that HM will not get this money today, but the money will be deposited into the registry of the court and he can obtain it when he turns 18.
Y usted tiene bien entendido, señora, que esta cantidad de dinero no lo va a recibir HM hoy día, sino más bien que este dinero se va a colocar en una cuenta, en un registro ante el tribunal. Y él va a poder accesar ese dinero cuando ya cumpla los 18 años para recibir el dinero. ¿Entiende?
Sí, correcto.
Yes, that's correct.
And it is your understanding that the total settlement of $8,200 is in the best interest of HM, correct?
Y usted tiene bien entendido, señora, que el monto total de $8,200 sí es lo más favorable para el joven, para HM. ¿Es correcto?
Correcto.
That's correct.
And you understand that the net portion of $3,000 is in the best interest of HM, correct?
Y usted tiene bien entendido que la porción neta, que es $3,000, es lo más favorable para el joven HM. ¿Es correcto?
Correcto.
That's correct.
I will pass the witness. Thank you, Ms. Martinez.
Cedo el testigo.
Mr.
Muchas
Whitcomb,
gracias,
do you have
señora
any
Martínez.
questions?
Sure. Ma'am, you understand that if the court approves the settlement, this is the total amount that HM or you could ever receive for any injuries he sustained in this accident.
Bien, en cuanto a las preguntas del licenciado Whitcomb, la pregunta es la siguiente. Señora, usted tiene bien entendido que este monto de dinero será, si dado caso el juez lo aprueba, esto será el único dinero que usted podrá presentar a reclamar a su favor y también al favor de HM tocante a este incidente. ¿Entiende que sería finiquito en este sentido?
Pues sí, correcto.
Well, yes, that's correct.
And this settlement was reached with the help of a retired judge at a settlement conference or mediation.
Y este acuerdo transaccional pudimos lograrlo con la ayuda de un juez que estaba jubilado, que nos ayudó a llegar a este acuerdo en una mediación. ¿Fue así?
No lo sé.
Oh, I'm not sure.
That's fine. And
No
of the settlement of $8,200, the medical expenses are going to be paid to the tune of $3,200.
Y de ese monto de los $8,200 del acuerdo transaccional, se van a pagar $3,200 en cuanto a los gastos médicos, ¿cierto?
Correcto.
That's correct.
That the attorneys on behalf of HM will be getting an additional $2,000, and it's the balance of $3,000 that's being set aside for HM for later on use.
Y que los abogados, los honorarios de los abogados estarán costando $2,000 de esa cantidad de dinero y los restantes $3,000 son los que se van a poner en el registro a nombre de HM. ¿Es así?
Correcto.
That's correct.
I have no further questions, Your Honor.
No tengo más preguntas, su señoría.
Mrs. Davis?
Ms. Perez, my name is Mari Perez Seves, and I am the guardian ad litem in this matter.
Señora Martínez, recuerda que mi nombre es María Aceves Pérez y yo soy Marifer Aceves y yo soy la abogada para el proceso en este caso, como la abogada ad litem. ¿Entiende?
Sí.
Yes?
And you understand that I was appointed by the court to represent the interests of your son, HM, in this case, correct?
Señora, usted tiene bien entendido que a mí me asignó el tribunal, o sea, el juez, para atender el caso representando a su hijo, el menor HM, para este proceso. ¿Entiende que es así?
Sí,
Yes.
Now, you and I actually had an opportunity to conference before today, and I also conferenced with HM, correct?
Ahora bien, antes de la fecha de hoy, usted y yo sí tuvimos oportunidad de tener una conferencia. También pude tener la conferencia con HM anterior al día de hoy, ¿cierto?
sí,
Yes.
cierto.
Yes, that's true.
And we discussed the settlement breakdown as well as HM's injuries and how he's doing today, correct?
Y cuando nosotros estuvimos conversando, pudimos hablar de la cantidad del acuerdo transaccional, la transacción en sí, las lesiones que sufrió HM y también hablamos de cómo se encontraba él hoy día. ¿Es correcto?
Sí, correcto.
Yes, that's correct.
We also discussed the settlement proceeds that will be placed into the registry of the court.
También nosotros hablamos del dinero del acuerdo transaccional, la cual va a estar colocada en una cuenta del registro del tribunal, ¿verdad?
Correcto.
That's correct.
And you understand that the $3,000 will be HM's funds when he
Y usted tiene bien entendido, señora, que los $3,000, eso será un dinero para HM únicamente. Y será para cuando él cumpla mayor de edad, cuando tenga los 18 años. ¿Entiende?
Correcto, sí.
That's correct, yes.
Do you believe that, well, are you asking the court to approve HM settlement because you believe it's in the best interest of HM?
Bien, señora, entonces usted le está pidiendo al juez que sí otorgue este acuerdo transaccional para HM porque a usted le parece que esto es lo más favorable para HM, ¿es así?
Sí,
Yes.
Your Honor, no further questions. I pass the witness.
No hay más preguntas, señor.
Ms. Martinez, do you have any questions for me? Do you have?
no,
Señora Martínez, el juez le pregunta si dado caso, ¿usted tiene alguna pregunta para el juez?
no,
No.
no me siento bien, no es todo
No,
bien.
I'm just not feeling well, Your Honor.
I'm so
just not
sorry.
doing well.
I'm going to ask your
Lamento que
attorney a
se
quick
esté
question then.
Solamente
Ms.
una
Raffi
pregunta rapidito.
or Ms. Aceves, so there's $8,200 settlement, $3,000 is going to the child, $5,200. What is the other $5,200 going for? Is that attorney's fees, medical expenses? Kind of how's that broken down?
It's attorney's fees and medical expenses, Your Honor. I listed it in my guardian ad litem report.
Your report, okay.
Yes, Your Honor.
2,000 is I'm sorry.
Sorry.
That's okay.
Go ahead.
Attorney's fees are $2,000. Medical expenses are $3,200.
All right. The court will go ahead and grant the judgment as requested. And it looks like there's been maybe an agreement, Mr. Whitcomb, if this is correct, that $1,312.50 be awarded to the guardian ad litem. Is that correct?
That's correct. And defendant has also agreed to reimburse for the interpreter fees for this session.
Perfect. Thank you so much. Does that need to be in the order somewhere?
No, Your Honor.
En resumen, señora Martínez, el juez ha otorgado su acuerdo transaccional y aclaró que los 8,200 son 3,000 para HM, 3,200 en costos médicos, 2,000 en honorarios del abogado y que la abogada para el proceso va a recibir 1,312.50 que ya está acordado por la defensa y que la defensa va a cubrir también los gastos del intérprete para esta sesión, de manera que está otorgado y aclarado todo en resumen.
Sí, acepto.
Thank you, Mrs. Davis, for your service. I appreciate it. And the court will grant judgment. I'm sorry. I think I just skipped a step. Did you want to go ahead and make a recommendation?
Yes, Your Honor. At this time, as the guardian ad litem, I'm of the opinion that the settlement is in the best interest of the minor child, and I would respectfully ask the court to approve the settlement.
Okay, sounds good. I'll go ahead and thank you, Ms. Raffi, for
Thank you.
reducing your fee. And Mrs. Savis, thank you for your service. Court will go ahead and grant it. Did you submit a separate order for your guardian ad litem fees, or just do you want me to include what's in the judgment?
I did 2 separate orders, Your Honor. They should be e-filed.
Let me. We
Con
have
la
a new.
Con la recomendación de la abogada para el proceso, el juez ha otorgado el acuerdo transaccional y la sentencia reflejará lo mismo en cuanto a la documentación se está revisando.
Sí. Gracias.
Thank
And
you.
Your Honor, I believe a duplicate copy of these documents were also emailed to your coordinator earlier this morning. So you should probably have them
Okay.
separate via email.
Okay, let me see if I can pull it up. We have a new case management system that just went into today, so I'm still learning how to use it.
Perfect time to try something new.
I know I think it could be really great once I figure out how to use it. I'm still kind of figuring it out.
We have a new system too, and it's been,
Yeah, it's
Okay.
great once you figure out how to use it, but until then, let me see. I didn't find that order. Let me see. Yeah, I see it.
I can resend it to everyone.
No, don't worry about it. I got it. So I have the judgment and the order approving guardian ad litem fees. That's it, right?
Yes, Your Honor.
Okay. All right, the court will sign that. You can get it offline probably by tomorrow.
Thank you very
Okay,
much,
guys.
Your Honor.
Otorgado se podrá. Muchas gracias, señora Martínez, que se mejore.
Ujú.
Hope you get better
Gracias.
soon.
You guys
Thank
hope you
you.
feel better,
Hasta
Miss
luego.
Martinez. You be
Thank you
safe.
so much.
And
Thank you so
you
much.
guys are excused. Thank you so
Thank
much.
you, Ms. Martinez.
Okay, cuídese mucho. Thank you all. Cuídese
Okay,
mucho.
bye-bye.
Take care.
Bye.
Bye.
Bye-bye.
All right, Mr. Heltowski, are you there? You're muted again. There you
Yes,
go.
Your Honor.
So I've read your TRO. I guess my main question is, did you put the other side on notice about this?
Yes, Your Honor. We actually already had a hearing, but there was no imminent threat because there's no eviction. This was amended, and then the certificate of conference filed on Thursday last week is when we noticed and then told Mr. Harder that we were going to have this hearing today.
And he's
So
just not
they've
here.
been aware of it. Yes, Your Honor.
Okay, the court will grant the temporary restraining order. So you're essentially moving to restrain the homeowners association from, or condo association from foreclosing. Is that correct?
Yes, Your Honor.
All right. And the temporary injunction will be on November 16th at 4 p.m. The 68th District Court, the 5th floor, and the bond will be $250.
Yes, sir, Your Honor. Glad
Anything
to,
else?
oh, just glad to have you back from vacation or wherever you were. We could change ago.
Oh, I'm sorry about that. Okay, yes, I'm back. All right, you be safe.
Yes, sir, Your Honor. Likewise.
We give you this.
Everybody have a great day.
Thanks. Let me give you- Okay, I'm not sure if I've signed this one or not. Can you double check to see if I've signed this? Okay, you guys are back. Welcome back.
Thank you, Your Honor. We made absolutely, positively no progress.
That's great. That's exactly what I was hoping you were going to say.
Your Honor, I have offered to counsel for defendant that he can keep his attorney-client work product privilege, that he doesn't have to produce anything like that. He just withdraws objections to everything else because he says, I don't have anything. I'm like, fine, if you don't have it, then you don't have an objection to it. You can't object prophylactically. We all know that from the rules of procedure. But he says, no, he will not. You would have to overrule the objection. Now, Your Honor, let me remind you, it's his burden of proof to prove whatever privilege or defense he has from producing whatever documents there are. And Your Honor, I would ask that that proof be produced now.
Oh, Miss Perez, let's see, is she still here?
Yeah, she is.
Okay, let me let her go. Ma'am, you're allowed to go. There we go. Okay, we'll go back on the record, Tony. I guess we need to go through these one at a time. Mr. Summerman, why don't you go ahead and share screen, whatever you want me to rule on.
Yes, Your Honor. Ms. Reisinger, if you would, please. And you're on mute, Alex. Good. Thank you, Alex. Your Honor, let me start with request number 2, a copy of each and every statement of any other party or any party's employees, agents, whether written or oral, in connection with the case. Again, Your Honor, if he has something that he himself has created.
I'm just going to rule on these, and if I need argument, I'm not trying to be rude, Mr. Summer. I just want to get this over with.
No, I appreciate you. Thank you.
Request for production number 2, the objection's overruled. Request for production number 3. It is overruled. Request for production number 4 is overruled. Request for production number 8 is overruled. Request for production number 28 is sustained. Request for production number 29. And when I'm saying objection, and just so it's clear, when I say overruled, I'm overruling the objection. When I'm saying sustained, I'm sustaining the objection.
Yes, sure.
29 is overruled. Sorry, it's sustained. Objection 20 is 29 is sustained. 30 is overruled. 31 is overruled, subject to privilege, obviously. Is that it or anything else?
That's it, Your Honor. And just to clarify, the ones that you overruled, you're not overruling my.
That's not all, Your Honor. We're not done.
Product. That's the only ones that are in the motion, Judge. And just to be clear, I was interrupted. When you say overruled, you're not overruling my attorney-client or work product objections, are you, Judge?
Right. If there's any type of privilege that you want to assert that's not core work product, then you would need to produce a privilege log.
Yes, sir. I understand.
Okay. There's some more. It looks like number 42. I don't know what a driver availability log is. What is that?
Alex, if you would.
Yes, Your Honor. Within the employee handbook for the defendant driver, he is required to keep track of his availability and his rides. It makes reference to this driver availability log as both belonging to Irving and as the responsibility of the employee. As he was a taxi driver who was going to pick up 2 passengers on the time of the incident, and he did receive a call, was responding to a call from dispatch when this incident occurred. We have asked that the availability log, if it exists, be provided to us.
What period of time?
Your Honor, you're correct. We did not put a time frame as to what time for the driver availability log.
What time do you want, Alex?
The day of the incident.
That's fine. Day of the, it's overruled, but you need to produce the driver availability log for the day of the incident. All of the which reflect that you were available. I'm not sure I fully understand this one.
Alex, if you would.
Yes, Your Honor. Similar to request 42, there have been several allegations from Mr. Scott that the driver in this case was not on a ride, didn't have a computer, didn't have any, and there's no record of anything about him showing the ride, accepting a ride as a taxi driver. So on that basis, we have asked that if there are any documents showing that he had accepted a ride, such as the phone number, a record showing that this phone number requested this ride, or a receipt showing the ride request from the two individuals, that those documents be produced. And if they don't exist, they don't exist, but if they do exist, we would like them. And we have tailored these requests that are more broad to a specific time frame when the incident occurred on the day in question.
Okay, the objection's overruled to that, to the extent there are any documents. And this one is the same one just for the whole day?
Yes, Your Honor.
All right, that's overruled as well. I mean, it seems like they're trying to kind of prove a negative here, but if there are any documents that exist about that, that's fine. That's overruled.
For both 45 and 46?
Yeah, 45 and 46. I mean, I think they all kind of are the same thing. That'd be in this driver availability log.
Yes, Your Honor, that's correct.
Anything else, guys?
No, Your Honor.
Mr. Scott, anything else?
Nothing else, Your Honor. Have a good week.
Just get me an order on all of this, Ms. Reisinger, if you could share that with Mr. Scott and get me an order as soon as possible. I'd like it no later than Friday so I can sign the order on Friday.
Thank you, Your Honor.
Yes, Your Honor.
Anything else, guys?
No, Your Honor, thank you.
You guys have a great day. Be safe.
So long, Judge.
Bye-bye. Okay. So, Tony, looks like there's a very good chance we're going to have trial tomorrow. So I am coming in tomorrow.
Okay.
Oh, oops.